So tonight we're going to be covering wills, lasting power of attorney, protection for vulnerable beneficiaries, and avoiding threats. If you do have any questions, please can you use the chat function rather than the question and answer function, and we will answer those questions at the end. Can I also just remind you as well that the webinar is being recorded, so please don't give any personal information. I will now hand you over to Wendy Hayes, who's going to be doing the presentation. She's also going to be supported by Sheila Nolan and Dermot O'Kane, who are going to be answering your questions and reading the chat in the background. Thanks, everybody.
Lovely. Thank you very much for that introduction. Good evening, everybody, and thank you for sparing some time to hopefully learn about what I think is a fascinating subject. So I'm going to share some slides which can be quite helpful. We were laughing about technology, so hopefully this will all go well. Right, that was me with a much better hairstyle. So my name is Wendy Hayes. I've been looking after estates and financial planning since the early 2000s. Hopefully, as we go through the seminar, you will pick up that you know, we are knowledgeable, but we're very friendly and plain speaking. And we get feedback from clients that this is very much welcomed with this subject, because it is renowned for being full of jargon and people can feel a little bit bamboozled, and really they just want some quite straightforward advice and education. So hopefully we will tick that off today. So just to be clear, estate planning seminars organise these events, but we as legals do give the advice, so that doesn't come from estate planning seminars themselves. And I think, as we've just said, Sheila and Dermot will be managing the chat. If there's fairly straightforward questions, they can often answer those in the chat. You can message them directly so that you can get a private answer, or if the general questions go in, we will try and cover those at the end. I normally try and get through the presentation in about half an hour, if that sounds okay. Sheila will put in a link that you can click through to fill an online form if you prefer, or you can ask for further information in the chat. So without further ado, I will crack on. So we quite like to set the scene first. A lot of people are quite apprehensive about thinking, first of all, about death. What happens if they're not around anymore? They start to worry about a lot of things. It's not something they've got a lot of knowledge or information about, and it can be quite a stressful thing. Clients really like to know what might happen before you sit down with somebody to get more information. So it's quite a theme throughout the presentation. So in order to give advice, then we would tend to need to understand a family tree, your assets, and any concerns or questions that you might have. And we go into detail of this further on. When we've chatted to people about that, we often give a little bit of education then in a very gentle way. But of course, we deal with issues all the time, and we have lots of different solutions for lots of different problems. And it's very helpful for you to understand maybe what some other people have done, or what you can do and what you can't do. We're not ever here to tell you what to do, and no estate sort of planning company should do that. We're there to give you information and guide you, help you understand what your options are, what the costs are, what you get for that, what you don't get, and then you can choose what you want to do. You can spread planning out. You don't have to do everything at once. If you were quite elderly and not in great health, then probably you would want to do things at once. But in most cases, you can spread things out over time as well. So if you imagine if you've a young couple with just under 18's children, they might be more concerned about appointing guardians when they're in the 20s. But as they get older and maybe their assets increase, they might want to start talking about other things as they get older. So the important thing is you're always in control. You do what you choose to do. It's very important before you ever sign documents that you understand them, and that you do agree that they are solving the problems that you had or the concerns that you had. And normally this is a combination of a will or wills. There could be trusts in those wills, lasting powers of attorney, and sometimes funeral plans. So it's just to set the scene of how it all works, so that hopefully that isn't something that you need to worry about. So why do we have to ask about the family tree? Well, it's really important that you think about who you would want to inherit from you. And individuals have different needs. So without always sort of just reading down through the slide, when we're looking at a family tree, we really need to understand who you might want to inherit, who you might not want to inherit. Is anybody in business? Is anybody suffering financial hardship at the moment? Might they be somebody who's going to go into some sort of voluntary agreement around their finances? Is anybody in a relationship that might be heading towards a breakdown? You kind of get used to this theme as we go through it. It's not the most cheerful subject. We kind of try and smile our way through it, but we wouldn't be doing our jobs if when we're chatting to you, we're not helping you identify where there may be some issues. And hopefully that's why when documents are produced, if anybody does that, then you're confident that they're right and we've really caught everything in the net that we needed to think about. Would any of your potential beneficiaries suffer from poor health? If they weren't alive to inherit, where would that inheritance go? Would it go to their children? Would it go back into the pot? So it's also just having to think about things like that. Would any of your beneficiaries be on benefits now? Might they be in the future? We need to think about how we would leave money to somebody in that situation, because you would be leaving money to benefit somebody's life, not necessarily just to be taken away in place of receiving benefits, in which case they wouldn't see any benefit from any money you left for them if it was left in a straightforward fashion. And vulnerable beneficiaries particularly, we need, when we're alive and we're looking after a vulnerable beneficiary, it's fairly straightforward. We have to think about, what if we lose capacity or can't manage the finances in our lifetimes and we've still got that vulnerable beneficiary to look after? And after we die, who is going to look after their interests? Who is going to manage the money for them? So by understanding who's in the family tree, we can understand what to chat to you about and what not to chat to you about. The challenge for us when we do seminars is we kind of have to give you loads and loads of information, because it's a general whistle-stop tour of things to sort of get you thinking. What I always want to reassure people about is the reason why we ask about families and assets and your wishes and concerns are, if you do seek further advice from anybody, they can tailor that advice to you then. So you're not overwhelmed by all this stuff, some of which would never apply to you. If nobody in your family is in business, we wouldn't have to burden you with talking about what might have to happen if they were. And we chat about other background things, previous relationships. We have lots of blended families now. They can be quite challenging and people can need help to think about how to manage that fairly and with certainty. And often ex-spouses, we want to be sure, don't in any way benefit. There's a little bit of a quirk that on some occasions, an ex-spouse who you are divorced from, fully divorced, decree nisi, if they haven't remarried and you die without a will, there can be circumstances where they can then still benefit from your assets. So that's something that usually makes people go, what? And that's something to just have a think about. If that's your situation, you need to get advice around that to ensure that you protect what you have to go to who you want it to do. Might you inherit in the future? You could sort all your planning out now. And if we're not aware something might come through in the future, we might have missed a trick to just create a flexible plan that would also work if some more money came into your estate. We particularly like to know about who you wouldn't want to inherit, because we need to put protections in place and you need to think about why you wouldn't want them to inherit, and then we can ensure that that's all robust. When you don't have a will, it's said that you die intestate. So the laws of intestacy come into being. What that means in plain English is the law says where your estate goes to if you haven't made a will to say where you want it to go to. So a good example of that is, if you haven't done a will and you have children who are under 18, the parent of those children would naturally become the trustee of any money that you were leaving to your children. Now, if you're no longer with that partner, that is something that often people wouldn't want to happen. So that's a big driver for some people to just have a think about what that means. So again, it can be a bit overwhelming throwing all this at you, but it's just to try and get you thinking about it really, and thinking about getting a bit of advice, and the advice is free, and that's just important to help you. So why do we talk about your assets? It's very important to understand what you have and what it means. Probably the wow, if we can give clients a wow factor, it's when we chat about their assets, because so many people don't really understand the pensions they have now or they've had in the past, what death in service means, what they would get as death in service. They don't always understand about insurance policies. And it's not that we aren't bright enough to read these documents. They are complicated and they're very boring. Now, to us, they're an important part of what we do. And it's essential that when we leave somebody, we've really helped them understand what the size of their estate is. And if they're missing any tricks, they've got a chance to put that right. And that's really important. So people feel reassured that they understand more if they were to have died yesterday, what that estate would have looked like. And we help them think about, if we, you know, I try and not keep picking too many examples, but if we had a married couple, you need to think about what would happen if one of you died. How would the person left be financially? What happens if both of you die? So that could be together, which is very unusual, or more statistically on a second death. So one's died first and then a second death, to have a think about who we leave behind then and have we made provision for people. People often don't think about where they're paying maintenance to a child who doesn't necessarily live with them. If they don't make provision in a will for that, then that maintenance payment would end when they died, and that's often not something people would want to happen. So that's, again, something to just think about, and it's something you don't think about without a little bit of advice. We chat about business ownership, if anybody in the family is in business. Probably a lot of people on the call aren't necessarily in business, but your partners might be. Often when you do planning, you do it as a couple if you are in a couple. Therefore, if your partner is in business and they die, guess who will be left sorting that out? That would be the surviving partner. So it is important, if somebody is in business, to understand more about that and make sure you leave each other in the best position that you can. We also spend a lot of time talking about how assets are owned. Do you own them jointly? Do you own them on your own? How is your property owned? Is there a benefit to owning that in a different way to how you have it? Again, this is personal advice, and it depends on everybody's individual situation. But before you can decide what you want to do, you need to understand what it is that you have. So it's a big part of thinking about your estate, understanding where you are now. And is there anything you could be doing now that was really sensible that doesn't even involve estate planning? A typical example is if a couple are getting older and they've both got assets just in their own names, of course, we're going to talk about lasting powers of attorney, and we talk about that later on. But a simple thing for them to do would be to get a joint account with some money in, so that if something happens to one of them, they've got access to that money. Sometimes it's all in one person's name. Sometimes a house is all in one person's name. People just need to think through what that means in the event one dies and how that leaves the surviving partner. Inheritance tax is something we do touch on. Will there be any tax to pay if you die when we've had a look at the size of the estate? Is there anything we can do about that legally to reduce that, which generally people are fairly keen to do? So again, that's just understanding what you have, understanding your options, understanding what you can do and what you can't do. There's certain things we are going to advise you can't do, even if you want to do, and we'll explain why. And you might not like it, but at least you'll feel happy you now understand why you couldn't do something. And a typical example is years ago, lots of parents used to just give their house away to their children, hoping it would avoid care and all sorts of different issues and inheritance tax. And that just doesn't work in this day and age. The courts have the powers to wind back and in effect put that property back into the possession of the parents. So it's very important you do things that are sensible. Otherwise, you'll find out too late that some planning that you did was a little bit disastrous, and once somebody's died, it's not easy to redo any of that. In most instances, you can't. And a big thing people are keen to ask about is any debts that they leave if they were to die. Which debts get paid? Which might you not have to pay? Can things be restructured that are a little bit more in favour around that subject? But the big one is, how are they going to be paid? And so just having, you know, a bit of advice around that, because there is, you know, quite a lot of debt around, and that's important. We don't want to leave families debt and trouble if we can help it. And then lastly, the sorts of things, your questions and concerns will be individual, but people ask things like, what if I don't have a will? And we keep picking up on that theme throughout as we go through this. How could I think about paying for care in the future? What are my options now? And so in general in life, the sooner you plan for things, the more options that you have. When things are left to the last minute, generally you have few or no options. So planning is always good. HMRC like us to plan. And so there are things you can do and things you can't do. And the earlier you look at that and understand that, the better. People worry about protecting their children's inheritance if they were to die first and a partner were to die second, if that partner were to remarry or cohabit or fall out with the children, especially if they aren't their children. This is a blended family situation. Then there's some good advice around there about what you could consider doing. Hugely important, you know, vulnerable or disabled beneficiaries, or even just mild learning issues where people worry that somebody will be able to manage finances. It's understanding your options on how to protect that. We talk about that a little bit when we cover the trusts shortly. So these are the questions that worry people. What's going to happen when I'm not here? Who's going to manage the finances of my son, my daughter, my sister, whoever they're sort of looking after at the moment? And how can we protect from a claim from somebody who we don't want to inherit? And that's something, again, that we need to know that person is there. We need to understand why we don't want them to inherit, and then we can put plans in place in the will to protect that and ensure that then they don't have a claim on the estate. Claims on estates are incredibly expensive, very stressful, and drag timescales out into years and years sometimes. So some good protection in a will is worth its weight in gold. Some clients have assets in different names and they need to just understand the impact of that and what they need to do about that. A typical one is doctors often have that they qualified in a maiden name as a lady, and if they've married, they've still got a lot of things in that maiden name, loans and stuff. So it's just to make sure that wills pick up an also known as name. And we talked about this before. Is it true if I leave money to my children without a will, it would go to their father? This is a mum asking that. Then, you know, the answer is yes. The parent, the surviving parent, is given that money in trust. And that is in the old-fashioned sense of the word trust. They're just being trusted to look after it and do a good job. And I don't have many clients who would agree that the parent of their children, if they've divorced them, would be the one they'd necessarily want to manage the money. Sometimes it is, and that's fine, but often it isn't, and it's just understanding that. I just try and throw a few facts in because there's lots of misinformation out there. At the moment, it still is only 1 in 4 of the population who might end up in long-term care as they get older. The statistics are still it's more women than men, but the age gap is narrowing now between the ages that men and women live for. It's something that's lessening, and also that's going to have an impact on those sorts of things, perhaps in the future for the age groups we have on today. So what options do you have? Really, you're looking for certainty and peace of mind when you do any planning. You don't want to leave a mess. You don't want to leave arguments. You don't want to pay unnecessary taxes. You want to ensure money goes to who you want it to go to. But in your lifetime, you want to keep control of it. You don't want to give things away. So really, you know, we're saying there, we minimise threats and we maximise the inheritance. That's what we're looking to do. Some people never do wills and do any planning, and that's fine. That's their choice. I always encourage anybody to get advice, and if you choose to not do anything, that's fine. You've had the information to make that decision. Basic wills are for straightforward situations, often for where we've got under 18s and parents' priority is naming guardians for them. So they are very much, I give this to them, and that's it. There's no more clever planning than that, really. So they can be restrictive if you've got a more complex situation. We'll talk in a moment about post-death trusts. Those are trusts we only need if we die. And then a lifetime trust, as it says on the tin, really, some situations we might need to have a trust now in our lifetimes. so that we've got everything in place for when we die. And even if we were to lose capacity, as a parent, for example, of a vulnerable child, that trust has already been set up. That child will still be looked after. Even if I'm living and I've not got capacity, I've already set all that plan in place to ensure that that vulnerable person is going to be looked after. And when I die, that still then just continues. That's an area that does get quite overlooked. People often have a plan for if they die, but they don't think as a parent or a carer, because it could be a sister or somebody who you are looking after as a vulnerable beneficiary, that if you lose capacity, then we've got to void them, because the will only comes into being when we die. And that can be a little bit of a gap that you know, when it happens is very difficult. We do go to the Court of Protection, and again, I'll chat about that in a minute. I try and follow an order to not give you too much information at once. We'll cover lasting powers of attorney in a moment, and I really will be very briefly over the business wills and funeral plans, because I think that's less key for what we're chatting about today. So a post-death trust is exactly what it says. We only need it to happen when we die. So an example might be, we talked about the property. I'm married to my husband. We have 3 children. We own half the house each. If I die first, on my death and in my will, it says my half of the house is held in trust for the children. My husband can live in it until he remarries or dies. Those are choices I've made. People make different choices. When he dies, I know that my children will inherit my half of the property in terms of value. That's watertight. I don't need that trust now. I only need that to happen if I die. So it's a post-death trust. We do use them for vulnerable beneficiaries and disabled trusts. We do use them all the time for children's trusts. So my children would inherit at 25, but I have given the trustees the power to let them have money earlier than 25 if my trustees, which is my brothers, if they think my children are sensible enough to get money before they're 25, my trustees can let them have it. If they don't think they're sensible, they can keep it off them till they're 25. More often these days, it is 25, because they don't tend to be too sensible with the money under 25. But again, that's a choice, and we chat to people about it. A huge one here is partners not married. If you don't have a will to protect this nil rate band of 325,000 tax-free if you die, the tax all comes on the second person to die. So rather than having 2 nil rate bands of 650, 325 each, the poor second partner to die, anything over their own of 325 would get taxed. So there's some very simple things. Unfortunately, the law's still a little bit behind on this. If you're not married, you don't have this transferable nil rate band to a surviving spouse. So that's always something we chat to. Again, if you're married, it doesn't apply to you. If you're partners, it does apply to you. And that can be obviously same-sex partners, any situation really where you're living together. We've even had it with brothers and sisters, just to make sure that what they wanted to happen if they shared a property was tax efficient. Lifetime trusts are, again, we need to set something up in our lifetime, and probably the best example was the one I referred to previously. There's lots of benefits for future generations. Lifetime trusts take the money outside of the estate, so it's outside of the estate for inheritance tax. We can protect people who are going to inherit in case they get divorced in the future. The money that we leave will never be taken in a divorce. It totally protects against challenges from people who we don't want to benefit. It helps us look after. They call them unreliable beneficiaries, which is probably harsh, but a good description. If you've got somebody who you want to benefit, who has got mental health issues or addictions, or they're just terrible with money, you might not want them to inherit directly. You might want somebody else to help them and manage the money for them so that they don't obviously do themselves any damage or get taken advantage of. Family trusts do protect from any beneficiaries who are on benefits, so you can enhance their life rather than just have their benefits stopped. This is where we can also protect from a sideways disinheritance. So again, going back to my case, at the moment, I'm only protecting half my house. if my husband remarries or cohabits. Through a lifetime trust, I can protect my whole half. So that could include assets and monies and other things if I wanted to do. He would get the benefit of a life interest in them, but when he died, that would be paid back to my children. So there's lots of things we can cover there, but the vulnerable beneficiaries is becoming very much the key one here. It's where people want to ensure that if they get older as parents or carers, and they either lose capacity themselves or just become too infirm to manage the affairs of that person they're looking after, then this is already in place to immediately kick in and start. The next people who we've named, the trustees, will carry on our good work. And after our death, they would still carry on the good work. Historically, people have only done this after they die, and that is a little bit of a gap and a concern. The lasting powers of attorney, I think what I'm going to do first is, just because I'm conscious that, you know, I go on and on a bit. So I'm going to play you a BBC clip because whilst it's not a nice situation, it's quite a good introduction to lasting powers, and that might help you think about some questions. So I'm going to just stop my screen share and see if I can just quickly launch that, because what I don't want to do is run out of time and not show you this clip.
Coma. There'd been 6 years ago, Heather Bateman's husband Michael was knocked down on a country road.
I saw him 1 minute, the next minute I saw him, he was lying on the ground. An ambulance came and he never stood up or spoke again. It was the most horrific thing.
Michael fell into a coma. They'd been married for 28 years, and as the main breadwinner, his wages paid the household bills. Had you both made plans for the future?
We'd written our wills. I assumed that would be all I would need for the rest of our lives.
But as Michael was still alive, Heather discovered she wasn't allowed to use any of his money. Heather couldn't legally have access to Michael's accounts whilst he was ill because he hadn't granted her power of attorney over his finances before the accident. With that in place, she would have had complete control over all of his money. Instead, she had to apply to the Court of Protection. That is a court set up to protect the assets of vulnerable people. Heather finally got permission to manage her husband's finances, but with very strict conditions attached.
I could never write a cheque more than £500. Our daughter had just started university and the fees were over £1,000. So I was sort of being asked to ask permission to pay my own daughter's university fees.
The system was overhauled in 2007 in an attempt to deal with the issues raised by cases like Heather's. But since then, there have been so many complaints that the system is being reviewed once again. The Ministry of Justice told us that the changes in 2007 do allow a more personalised approach and give most people who deal with the court greater flexibility over how money is spent, whilst ensuring safeguards are in place for vulnerable people. The only way to avoid this additional heartache at such a difficult time is to appoint somebody as your lasting power of attorney. But despite the government's advice that everybody should do this, only 135,000 people in England and Wales registered one in the last 2 years. That is less than 1% of the population. Lawyer Julia Avery is an expert in this field.
Lasting powers of attorney are a document you put in place now so that the right kind of decisions, the decisions you've made for yourself, can be made by someone else for you at a time when you can't do it.
Right, so I'll stop that there and hop back in. Just bear with me a sec. Go back onto my presentation. Keep me on track. So hopefully that's back on screen. It's obviously a bit of a dramatic one, and it's a year or two old now. So actually a lot of people over COVID have made powers of attorney now, which is a really good thing. People were locked at home, they were shielding, they were stuck on holiday, they were in hospital. And so it really did increase awareness. And so that has improved enormously. We generally say if you're over 55 and or you're in business and or you have health issues and or you're single and or if you've got assets in your own name, these are all problems that we see all the time. If you were to lose capacity, having people to help you or even if you just can't get out the house. There's two kinds of lasting powers of attorney. One is for your property and affairs, so that's basically anything to do with your money and assets. You are allowed to let people have that even if you have got capacity. So if I broke both my legs, I always use myself as examples, but if I broke both my legs, I'd need somebody to go and do stuff for me until I could get back on my feet, literally. Once I was better, I could take that back off them and I could manage my own affairs again. If in the future I were to lose capacity, I could be in a coma, I could be high on medication, I could have an early sort of dementia disease or disease of the mind, then my whoever I've appointed could then stand in and look after my affairs for me. The health and welfare one, you can only have enacted if you haven't got capacity. So if I'm lying in a hospital bed and I'm not well, I can't just not be bothered to make decisions for myself. If the medical profession can talk to me and get answers, I have to give them those permissions. Only if I can't, so again, we're back to comas or high on medication, or I'm just not of sound mind, then my family can step in and represent what decisions they think that I would have made. And that's what a power of attorney is. The signature is as good as the person's. So if my son was acting for me, his signature would be as good as my own. He could sell my property unless I put something in to restrict him. And if he was making a medical decision for me, he is tasked with trying to make the decision that is in my best interests and is closest to the decision that he thinks I would have made myself. So often around care, the powers of attorney are really important. You need access to money. You need to be able to make decisions for people who are poorly and unable to make decisions for themselves. That could be where they're being cared for, whether they have life-sustaining or life-ending treatment. It can cover so much, and it's something that it's important that you have, but you hope you never need to have to use. So the slides are usually available, so you can click on the link. You can do powers of attorney online yourself. That's on the Office of Public Guardian's website. It isn't easy. We sometimes advise people to help them to be able to do that. In more complicated situations, they're not really possible to do yourselves because you have to get capacity signed off by a professional. So those are often the ones that we do. And they aren't easy documents, and clients often come back to us and say, no, will you just do them? So, but do have a look at those and see if that's something you think you could do if you want to do. And I'll see if that will just click on. I'm going to just skip that one because I'm very conscious of time. I'd just like to wrap up by leaving you things to think about. Executors, if you weren't here, who would you want to look after everything? So what does an executor do? Basically, they sell everything and distribute everything to who you said in your will. Who would you trust to do that? Should be somebody who's good with forms, good with money, somebody who you trust, somebody who's a steady person. Guardians, have you got children under 18? Who would you want to look after them until they got to 18? How would they manage financially? Would we need to name a reserve? You might name your parents now, but in 10 years, your parents might be too old. Who would we have in reserve for that? And trustees, after the executors have done their job with the estate, they've got this pot of money, big or small, they pass that on to the trustees. The trustees look after that money until the children or the beneficiaries are the age that they're going to inherit it. Or in the case of a vulnerable beneficiary, they will always be looking after that money for them. Do you pay child maintenance? How's that going to go on if something happens to you? Do we still want that child to receive that money? And what are the ways we can do that? People put lots of wishes down, and that's fine. I always say, if you were sat on a cloud up there, what would you wish you'd have told people? Get that down in a letter of wishes. It's so useful for the executors. If you want them to stay in the family home, the children, if you want them to continue with the religious education, that's the sort of stuff you'd pop down. Also, it's not very cheerful. We think about charities, we think about pets. Pets are very important to us these days. Who would look after them? Do they need money? Is there anything we want to tell them about it? And the one scenario that people struggle with that is, you know, even less cheerful than everything else. If I'm not here, my husband's not here, and our 3 children aren't here, where would we want our estate to go? That's sometimes light-heartedly called total wipeout, backstop beneficiaries. That's just thinking about, if somebody's not here, where would you want that money to go? And that's something that does need a little bit of thought. But really, it throw a lot of information at you. Really, it's just trying to help you believe that there's something out there for you, even if you choose to do that yourself or just get advice and choose not to do anything. Do get advice. We do want to protect things, and we do want them to end up in the right hands, and there's lots and lots of great ways of doing that, but again, you just need to understand what your situation. Every 3 or 4 years, people often do review the documents because things change, and that's fine, and that's normally very small fees if somebody needs to revise something. And the bit I always, because we don't have many happy notes to end on in estate planning, but the best way to reduce your estate is to spend some of it as you get older. And I have so many clients who won't even buy a winter coat because they don't think they'll get the money's worth because they're getting on a bit. And it's such a shame. You know, don't neglect your own life because you're really obsessing about leaving money to somebody else. There's a balance to be had there, and we do talk to people about that as well. So I'll probably run over a little bit there. I hope that's lots of information and answered lots of questions as well, but maybe hand over to Dermot. Thanks for listening, everybody, and see if we've any questions we can tick off.
Thanks very much, Wendy. Yes, obviously the issues around powers of attorney, lasting power of attorney and deputyship. We have a question here, which is, if I can paraphrase, is that someone who owns their own home just now and they have children who have various levels of autism, and they are due to receive and inherit money in the future.
Yeah. So
what would be the best advice in that scenario, and specifically around deputyship as well? Thanks.
Okay, so to cover the money off first, really, you've always got options of doing nothing, but that's not why we're all sat here talking. Ideally, you want to set up the Rolls-Royce solution is something like the lifetime trust, because you are putting everything in place now, and no matter what happens, you will have named who deals with that asset or money without it passing into the hands of those beneficiaries who is just not going to be appropriate. So we may sell a property and generate the funds and keep those funds safe so they don't affect any benefits or any alternative care provision or where somebody may live. We don't want that to be influenced by the fact that there is some money that's there to help them. Most people want the money to be used to enhance their lives, not just drag the life to sort of a basic standard if they're not around. That's the sort of Rolls Royce. That's completely future-proofing things. You know, that's not always affordable or appropriate. It's so hard to generalize, but certainly a lifetime trust will ensure that if you die, that those assets are going to be in safe hands to again be protected to only benefit children. So it's not a basic will situation. It is something that is more complex. It does involve a trust, and it does involve you thinking about who would look after that money if you weren't around. When it comes to lasting powers of attorney, the Mental Capacity Act does ask us to assume that everybody has capacity unless it can be proven otherwise. So the first port of call is really, do we feel somebody has capacity and can understand who would they nominate? Can we get those documents in place? The more straightforward route, and that would be a standard way of doing lasting powers of attorney. If not, yes, if we can't, we have to look at the court of protection route. It is more costly. It does take 9 to 12 months. Often it's more at the moment because of all the backlogs of COVID. So really, if you're in that situation and you're getting older as a carer, probably starting that process sooner rather than later is sensible. And then that's just there, ready to go if we need somebody to step in and have all that plan ready to go. But the ideal scenario is you can get them in place now. You need to think about powers of attorney for yourselves as the carers, because as we've said earlier in the presentation, if something happens to you, but you've not died, the plan we had hasn't started yet. And so we need someone to step in for you in that case as well. So there's quite a lot around there. There's nothing that doesn't have a solution. It's just understanding the individual situation to give the right advice and cost that out for people.
I think
I've just got one in the Q&A. It says our son is 16, special needs and no concept of money. Do we need a deputyship or power of attorney for when he reaches 18?
The answer's probably yes, is the official answer. But whilst we're around as parents, we can usually sort of bumble along. My concern with choosing that route is when we're not there as parents, we've got nothing. So yes, it is something to start thinking about. But you can structure your assets with somebody to look after them, and you will find a way forward with that without necessarily going to the Court of Protection at that time. So again, it needs thought. You don't necessarily have to have it whilst you're around as parents, but it's understanding when you're not around, at what point are we going to get it? So the Court of Protection are going to appoint a deputy. Well, we don't need a deputy at the moment because you're here and you're acting. So we need to get the courts to appoint you, and then maybe we have reserves who would step in if parents or a carer weren't around anymore. So it's kind of yes and no. You do want to be thinking about it. You want to try and get appointed, but the authorities are still very good at the moment, in our experience, of working with parents of children even in their 20s. You know, they're not forced to go to the Court of Protection, but I do think that's only putting it off, and at some point it does need to be faced, because we aren't going to be here forever for them. And if they outlive us, which hopefully they will, then we won't have left them anything. So it's something to sort out. I'd probably sort money out first, and then I'd maybe think about the powers of attorney for them through the Court of Protection.
Got another question. Firstly, the one in the chat says, can we get advice and support with what is the best way to do that?
Sorry, I just missed the first bit, Sheila.
Can we get advice and support with what is the best way to do that?
Yeah, absolutely. I mean, this is, the aim of these seminars is never to sell. It's to try and just get information out there, get people thinking about it. Anybody can decide to go and get advice for themselves. We are absolutely here and happy to give a free chat to help people understand their own situation. And the difficulty with us, it's always a challenge on the seminar that everybody's situation is different. And so it's very hard. What you really want is your own little roadmap of what to sort out when, what it'll cost, what it means, what it'll do for you, what it won't do for you, and you work through that plan. But it's a personal plan. There's just not a one-size-fits-all solution at all. And obviously things do cost money, and that's not always appropriate. So sometimes we've to give the best advice that you can afford, and maybe in the future that gets revisited. So, there's lots of things we'd all like to do, but we can't afford to do at this stage. So good advice is also balanced with what somebody can afford to do. So we try and set priorities and help people. So the answer is yes, that advice is absolutely out there, and we're very happy to also give that advice to people, following seminars. It's really important.
Here's a question, Wendy, which I was actually asked 2 nights ago by a lady. This particular question is around someone has an adopted child. So should anything happen to, say, the parents and the natural born child, without a will, do the legal birth parents of that adopted child have any say in the inheritance if that adopted child is the only one left in the family? And I was asked this 2 nights ago, and I'd like to hear your answer.
So, well, this is pressure then. So as far as I'm concerned, the answer to that is no. It's absolutely severed the tie on adoption. There is no two-way street about that. So even without a will, the adopted child, if they were the only survivor, would inherit. Even through the laws of intestacy, they would inherit. An adopted child has absolutely the same rights as a birth child. The natural parents do not come into that at all. Trustees would have to be appointed. It's a bit messy if that child was underage, but yes, that it wouldn't in any way involve adopted parents. I hope that was your answer as well, Dermot.
Absolutely. Thanks for confirming that. Very much so. You must have answered all the questions. There doesn't seem to be any more coming in.
Good. Well, I don't know whether that's good or bad. Hopefully it's good. I mean, I hope everybody appreciates that we've just changed the presentation again recently to try and soften it a bit and make it a little bit more like how we would talk to you if we were with you. So it's very much this plain speaking. You can ask us anything you want and we would try and give you the best answers and the advice. You know, we're plain speaking people. We do a lot around difficult scenarios because we deal with a lot of probate, which is the process when people die. We can feed back in a lot of things that we find didn't go well when somebody's died to make sure that we get those into wills in the future. A lot of the probate that we do is for wills we didn't do, thank goodness. A lot of it we did do them, but where we didn't do them, there's some really messy situations, and often when there's no will and the families are arguing, or it's very complex situations. So we just want to really reassure you that your situation, we need to understand that to give you that advice for you and talk to you in ways that you understand and answer any questions and let you think about things, and normally follow that up with a recommendation letter, and then you can let the dust settle and have a look through that. So it is a lot of information to throw at you, and it's only a tiny bit of the information that obviously we all have in our heads, but hopefully it just starts you on a journey of sort of getting some help really and getting some advice.
And I say that I would say possibly almost everyone needs to understand that there's no one size fits all. Almost everyone on this call would have what we would call unique circumstances, and very much would appreciate individual advice. And she just put up the link there. If anybody wants to hit the link, they will get access to speak to Wendy directly by appointment, and that can certainly be arranged. As I understand here, there's no cost for that, correct?
Absolutely, absolutely. Yeah.
But make use of that, guys. Make use of the free offer that comes along with having a chat with Wendy, by all means.
Fantastic. Well, shall we hand back to Sandra and see if we wrap that up? I think obviously I could go on for hours about it, but I struggle. Dermot, I think, would be in there as somebody happy to have a few pints of Guinness with me whilst we talk about it. But that's probably enough for everybody for one night. So thank you for listening.
Okay, thank you very much, Wendy, Sheila and Dermot. I hope everybody found tonight's webinar very useful. Just to let everybody know, this session has been recorded and we will be sending out the link to all the attendees as well as the contact details. Just to remind you as well, Seashell Family Services do provide and will be providing further webinars and events covering a range of subjects for families of children and young people with additional needs. Please visit our website, seashelltrust.org.uk, for further events and details. Thank you very much, everybody, and good night.
Bye-bye.
Thank you.
Bye.
Good night.
Good night.